for all of our students, Bill Reed provides legal consultations to students free of charge. At the end of the session, we will let students know how you can go and book an appointment. So hi, Bill. Thank you for joining us for our family law info session this week. To get us started, I'm just going to do a bit of introduction on who you are. So for all of our students, Bill Reed provides legal consultations to students free of charge. At the end of the session, we will let students know how you can go and book an appointment to meet with Bill. And just so everyone is aware, Bill does cover legal advice from everything from family law, like we'll discuss today, to immigration, criminal law, real estate, and business, and much more. He will also help with notarizing documents or any other legal assistance that you might need. So without further ado, I will pass the floor to you, Bill. Thank you so much for doing our session for us today.
Thank you, Amanda. And yeah, today we're talking about some family law issues. And like any of the sessions that we've done, they're not going to apply to each and every student, but they'll apply to quite a few students. Not all students are in relationships of any kind, but quite a few are, because I see so many students consult me about family law matters that we thought it would be good to have a chance to talk about some of the basics and have it available for students to refer back to online. And then, of course, they can always contact me, as they do anyway, and as well I'll remind them how to do. So, talking first about marriage, and as most people know, marriage is a legal status that can only be acquired through specific procedures established by a government authority. However, a marriage that takes place in one jurisdiction is usually valid throughout the world. People who are married in Ontario can go elsewhere in the world and say that they're married. And people who come to Canada from other countries where they're married, well, hopefully they have some kind of proof, such as a marriage certificate, and they can come to Canada. They were not married in Canada, but they are married while they live in Canada because they were married in another country. So in that respect, most countries respect marriages that were performed in another jurisdiction. And we can move on. Now, common law is not a status conferred by any one authority. So different authorities establish different conditions that constitute a common law relationship or common law status. Even in Canada, this happens. Different authorities may require that cohabitation take place for different periods of time before they recognize it as a common law relationship for their purposes. And an example, in immigration situations, if a Canadian is seeking to sponsor a common law spouse, the two parties must establish that they have been living together as a couple for at least 1 year. That's the period of time. No need to establish that they have children or whatever. For family law purposes under the Ontario Family Law Act, for the provisions of that act to apply to a common law situation, a couple must have been together at least 3 years, or at least 1 year and have a child. So the thing is, like I say, there's no one entity that says you are now a common law couple, the way that there are authorities that can say you are now married. There is no one entity that can confer that status, but different government agencies, for their own purposes, may therefore establish what the requirement is before they will recognize the couple as common law for the purposes of what they're doing, be it immigration, be it family law proceedings, or whatever. And we can move on. So a couple that is either married or common law may become separated just by establishing separate residences. Married couples sometimes think they need what they call a legal separation, and there really is no official legal term of legal separation. A couple is separated as soon as whether one moves out or they both move out of where they were living and each go somewhere else. As soon as they have separate residences, they can say that they're separated, and it's just as legal as anything else. They don't thereby necessarily have all of their affairs discussed and resolved, all of their assets and liabilities and anything to do with children, but they are separated as soon as they are, in actual fact, living separate and apart. Uh, but divorce is a separate matter. That is like marriage. Divorce can only happen because an authority that has the power declares a couple to be divorced. Someone who has lived in Ontario for at least 1 year may apply for divorce if they have grounds. And grounds may be living apart for at least 1 year. Again, that's separate from living in Ontario. The party applying has to have lived in Ontario for at least a year. The couple also has to have been apart for at least a year, or the party applying has to prove adultery or cruelty. Years ago, divorces were not granted so readily based upon separation. And they really were not granted unless the couple was apart for, well, one time it was 7 years, and it was reduced to 3 before it was reduced to 1. So more often the couple had to, one spouse had to prove the adultery or cruelty. But that was difficult because, it got messy, and the question of, well, who's to blame, whatever, even if, one party committed adultery, is there more to the story than that? Well, judges got tired of having to hear about the adultery and cruelty. And this is why in Ontario, in the 80s, in fact, the government reduced the time frame for what they call a no-fault divorce, a divorce based upon separation, to just 1 year. And that really, even if a couple feel that they have evidence, one of them feels they have evidence of adultery or cruelty, the year's separation is still the fastest way to get the divorce. And other issues I mentioned, such as division of assets, property, support, issues pertaining to children, can all be resolved regardless, in a fair way, regardless of what the reason for the divorce was. So the grounds don't so much matter. However, again, separation, yeah, just be separated. Divorce, it does take the authority to grant the divorce. Again, a Canadian divorce should be recognized throughout the world for legal purposes, even if the marriage took place somewhere else. A couple could be married in another country, come in, as I said, having lived in Ontario for at least a year, be divorced in Ontario, even though they weren't married in Ontario. So anyway, there we go about separation and divorce, and we can move on from there. So I mentioned about a couple that separates, needing to consider dividing assets and debts, for one thing. And in the case of a married couple, most of the assets and debts will belong to both parties equally, to each of them equally, regardless of which of them is the registered owner, regardless of who earned money or who did what. There are a few exceptions. A couple can take out of a marriage what they brought into it at the time when they got married. But other than that, what they acquired during the marriage, for the most part, is divided equally. Then they will also have to deal with the issue of spousal support, meaning whether one spouse pays the other ongoing financial support. And they will have to really deal with these issues whether or not they eventually divorce. And some couples who separate deal with these issues, assets, liabilities, support, and never divorce. In some cases, that's because of their religious beliefs, which may be against divorce. It may be because they don't see a need. I mean, the main reason why a separated person would want a divorce would be to remarry to someone else. If they never intend to do that, a couple may be separated for years and never divorce. So common law partners, for the most part, it's not the same where assets and debts are concerned. Common law partners who separate normally keep whatever is in their respective names and just have to divide whatever really is in both of their names. However, the issue of support still exists much the same way as it does in a marriage, where one party to a common law relationship may owe support to the other after they separate, depending upon how dependent the other was on the one potentially paying the support. And we can move on. I mentioned as well children. Now, anytime that two parents don't live together, they need to deal with issues of custody, access, and support. And when I say anytime two parents don't live together, sometimes they are married and they're separated. Sometimes they weren't. Maybe they were common law. Or in some cases, two parents never lived together. In any of those cases, though, if they're not living together now and they have one or more children together, then they do need to deal with the issues of custody, access, and support. And they may do so by way of an agreement. If they do any kind of separation agreement and they have children, the children would be dealt with in the separation agreement along with issues of assets and liabilities. If it's a simple situation that they don't have much in the way of assets and liabilities and they can communicate and agree fairly readily, then they may be able to do things by agreement, and it may even be oral, at least for a while, if that works. But if they're not able to come to an agreement, then either one has the right to file a court application, and a court application will result in a court order. However, that also can be agreed to by both parties or imposed by a judge. Now, what I mean by that is, like I said, a couple may be able to come to agreement without having to go to court, and that's great. They may find that they're not able to do that, so one of them files a court application. Well, once they fill out court documents and they have to file them and go to court once or twice, sometimes then with the assistance of the court staff, they're able to come to an agreement, even though they weren't, without taking those steps. It doesn't always require that a judge impose the resolution. Sometimes the couple who weren't able to agree are able to agree in court without the judge having to impose the resolution. Other times, yeah, it takes a judge, ultimately, potentially in a trial, or there are other kind of hearings along the way, but a judge might in the end be the one to impose the solution, say, well, here's what's going to happen as far as custody, access, and support are concerned, whether either or both parents like it or not. But that's only if, even during a court procedure, the couples aren't able to come to an agreement themselves. And we can move on. So I talked about custody, access, and support. And custody of a child pertains to who makes the important decisions in the child's life, which is about things like health, education, extracurricular activities, and religion. The custody may be sole custody, where one parent makes all of those decisions, or it may be joint custody, where the parents make them together, even though the parents don't live together. Or it may be shared custody, where what mainly happens is that each parent makes the decisions when the child is with them. And they don't necessarily have to communicate in that way, the same way as they do in joint, where in joint custody, they do have to discuss and agree, even though they don't live together. And it may be the only thing that they discuss and agree on if they're living separate, and that's fine. If they are able to make joint custody work, whereby they discuss and agree on issues pertaining to the children, then that's great. They may agree to have that. Courts don't very often order joint custody because if a couple can't agree to have joint custody, they're not going to be able to agree very well within the context of joint custody. If a couple can't agree, then a court more often has to order either sole custody to one parent or shared custody. But again, custody is about making the decisions. It's not about where the child lives. That's just the issue of the child's residence. And in the next slide, we'll talk more about that. Where the child lives is residence. And therefore, it's possible that one parent will have sole custody and be the child's primary residence. That is common. But theoretically, it's possible, and it does happen, where parents have either joint custody or shared custody, and still the child's primary residence is with just one of them. Or it may also happen that a child lives equally or close to equally at each parent's residence, but only one has sole custody. So again, custody and residence are two separate things, and there are different combinations that can occur depending upon various factors, like how busy at work or otherwise one parent is, any medical limitations they have, any other children they may be responsible for, whether they live further away. There are various reasons why, but again, residence and custody are two separate things, and both need to be worked out either by the couple or by a court. And we can move on. So a parent that the child doesn't live with may be granted access and normally must pay child support in amounts set by the government. Access may be on specific days and times, either by agreement or by court order, like every Wednesday from 6 to 9 p.m. and every second Saturday from 10 to 3. That's what could be agreed to or could be in a court order. Or it may be left to be agreed between the parties each time it takes place, just reasonable access on reasonable notice. One parent may say to the other parent, and perhaps the child lives with, may say to the other, could you have the child this Saturday? I have a job interview at 10, so could you take the child Friday evening, and I'll take the child back maybe Saturday afternoon. And then the next week it'd be different. If a couple again can communicate and just make those kind of arrangements on a day-to-day and week-by-week basis, that's great. And then the parent that the child doesn't live with has access, what we call reasonable access on reasonable notice. Sometimes it's called liberal access on reasonable notice, or meaning like as much access as possible. But the common thread in any of those expressions is that the couple just agrees from time to time as time goes by. And the amount of child support to be paid depends upon what percentage of the week the child lives with each parent. If the child lives at least 60% of the time with one parent, there are child support tables that set amounts. If the child lives between 40 and 60%, like 55-45, even 59-41, with each parent, then the child support tables do not automatically strictly apply. And as necessary, there are further steps to be taken, and I can assist any parent in that situation. But the child support tables do exist to set child support depending upon how much of the week the child lives with each parent, what province the child is in, and how many children the same set of parents have, as well as the incomes of the parents. Pardon me. So I say all that to say that there are child support tables, and I can assist any student who is a parent in using them. And that brings us back to how to contact me. And Amanda, maybe you want to talk about my email address and this form?
Yes, so the email address will be put in the chat. So yes, students can visit thessu.ca/legal advice to contact you, and then just fill out the online form like showed on the screen. Additionally, they could just email you directly, and they would just have to provide their student number. Yes, you are definitely always available, and you get back to students probably faster than anyone at the SSU. So thank you.
No problem.
Thank you also for covering the information today. I'm just going to take a quick look at the chat to see if any of our students are asking any questions. If not, again, all students, if you do have questions after this session, you could definitely reach out to Bill. As mentioned earlier, the session will be on our website as well under the legal advice page so that you can view it after.
Thank you, Amanda.
Awesome. Well, thank you for joining us today. It doesn't seem like we have any questions, so thank you to everyone as well who visited and came in. And like I mentioned, you can always reach Bill through the legal advice page or catch a recording of today's session.
Thank you, Amanda.
Thank you.